Hi friends from around the world, double patenting. So what do you think about this? Is it an interesting case which is from 2029, June 2029, from the EBoA, which is quite interesting, I think, to have it revised after 40 years, so to say, of the existing of the EBoA system, or more than 40 years. Now, what about the trademarks? If you make a double filing for the same trademark, would that be possible? Well, if you went through other videos, and namely the video with regard to monopoly on the trademark side, there was the, so to say, evergreening, that possibility of filing the same trademark at a later stage and having again, so to say, the grace period in your favor, meaning that for 5 consecutive years from the filing of that trademark, you do not need to prove the use of the mark on the request of the other party in inter partes proceedings, such as opposition, for example. So you can go for the opposition feeling free of having to prove genuine use, and that was considered a bad faith. Now, have we advanced with regard to this? Well, the bad faith was not in absolute grounds. It is very difficult for the examiner to look into the head of the people, what is their intention to use it or not to use it. There's no such thing as writing, I promise to use this trademark within the next whatever time it is. So it is not on the absolute grounds. It is not an opposition ground as well. So bad faith cannot be in trademarks being raised in opposition. So it must be only on in invalidity proceedings. But invalidity proceedings are not brought by the agency itself, by the trademark office itself. It must be a third party who proves then, and who has the burden of proof, that bad faith was there. So it is a randomly and arbitrary control instance. And so it is the same thing with regard to designs. Designs will be registered immediately without proving of what is previously being published, etc. It must be new, yes, but it is not being examined whether it's true, it's newly true, truly new. And then only in invalidity proceedings it can be, so to say, but it is again due to the market forces which, well, we do not control, and there is no systematic control of the market on what is new and what is not new. No? So this is the situation on the design side. How is it with patents? Well, in the first place, the patent is much more expensive, and the proceedings may go to 2 to 4 years or so in order to get a patent. So, and it is more expensive, right? So why would somebody in the first place do a double patenting? Well, you know, the patent is 20 years, and 20 years from the beginning, from the filing date. So 20 years, you know when it ends. And a monopoly, to have a patent in your monopoly, you can decide, you can license out, you can monetize whatever you have a monopoly. So this is a good situation, and you want to prolong it over beyond the 20 years. And then, well, at a certain moment you say, well, I will do another patent filing for that, and I will go 2, 3, 5 years more. So that would be the logic behind, but it would circumvent what would be the logic that one patent, one invention, one subject matter of the patent would have a lifetime of 20 years from the beginning, and then being open to other competitors for boosting the innovation. So that is the situation with regard to patents. And what are the double? What does it mean, the double patenting? Well, double patenting existed since the well, not the beginning, but since the days, early days of the European Patent Convention. And there's an established practice that double patenting, there are, in the abstract I mentioned them, that double patenting is so to say a ground for refusal of the patent. But it was not clear until 2021 what is the exact ground, or what is the exact limit, or what is the exact scope of refusal this double patenting has, and therefore is the importance of the decision which I want to talk you through today. And it is about Article 125 of the EPC, the European Patent Convention, which says, well, simply here on the screen, it says, well, the general rules are applicable where we don't have a specific rule with regard to the EPC. And in EPC, there's nothing on double patenting. So the general rule is, well, what the member states are doing is what we do as well. Now, the problem here is the member states are not homogeneous with regard to their approach on double patenting. Some, like the UK, for example, they say if there's a European patent and a national patent and they have a double, the identity of the applicant, the date and the subject matter, then it should be refused, one of them, the later of them. And with regard to the invention, it is not the subject matter, the invention. And with regard to two UK patents, same thing. If they refer to the same invention, same applicant, and the date is also the same, then one of them should be refused. Whereas in others, they are probably more, not probably, but some member states are more narrow. They refer to subject matter, for example, rather than invention. Or they do not say anything about double patenting. So my point here is the EPC, the European Patent Convention, refers to national member states' law, and the member states' law is not homogeneous, is not clear, so where the problem comes from, you see it. Now you have the questions which have been sent by the technical board to the enlarged Board of Appeal of the EBoA. And here are the questions on the screen. The first is on, can a patent be refused if it claims the same subject matter as a granted European patent to the same applicant? That is the essence of the first question. And the second question, in essence, says, so if so, do one of the following matter: the same date, the division application, and or the priority. So these were the two questions which have been referred to. There was another questions on the legitimate interest. I will go a bit later into it if I have time. So the decision, what does the decision say? Well, the enlarged Board of Appeal, they said that Article 125 is the ground for refusal for double patenting. So whereas the member states are, it does not enter into the discussions what is the exact law they draw out from the member states. It says, well, there's a general rule in the member states that double patenting is not possible, is not desirable. So that is also the ground for refusal with Article 125 of the EPC. So that is the first thing. The second thing is the subject matter and the applicant, the same applicant and the same subject matter, is the determinant feature whether you have a double patenting or not. So that is an important issue, and it refers to the first question. Now, as to the second question, it is quite clear as well. they're irrespective the other three issues, meaning the same date, the divisional application, and the priority issue. These are not determined with regard to qualification of a double patenting. So this cannot be held against or it must not be, so to say, complied with in order to be refused. So it is just these two, quite simple. It is about the subject matter and the same applicant, which must be identical in order to be refused as a double patenting. Now, it does not say something about the overlapping claims. There may be one filing has 6 claims, and there is one claim which is overlapping and a second filing afterwards, or at the same date or whatever. So what is about the overlapping claim? Probably the overlapping claim will be refused, whereas the others may be allowed. Or it may be assessed without that overlapping claim. But it is not so clear. And the third one is about the legitimate interest. So the technical board wanted to know, what about the legitimate interest of the party when they are filing, when it is filing their application. And, well, the enlarged board, they didn't say anything about the legitimate interest of the party. So it is not about whether there is or not a legitimate interest of the party to have that filing being done. It is, so to say, out of scope. The enlarged Board of Appeal and, well, the EBoA probably, they will not focus on whether there is or not a legitimate interest from the party. So what are the consequences we should draw from that case? Well, first is not to file identical claims, right? If you have claims which are closely related to the other, well, you should do your utmost in order to not being assessed that the claims are identical, even if there's overlapping filing, etc. Please be aware that there are no, so to say, exceptions from the board's decision. So there's no possibility to escape if the conditions are fulfilled. So it is therefore important that identical claims should be avoided. Or you can file with the national office. That would be a possibility. So you file at the European Patent Office and the second filing, and you will get the same, right? You will get a national patent. That is what the European Patent Office system is about. And the second filing you do at the national office directly. That would be probably a possibility where you can go around. So the reasons, they do not matter. What we have here is now clear guidance that double patenting should be avoided, and we see, well, you see now that it has become an issue with regard to the technical boards, which know exactly now how to react, and they will revise this with regard to double patenting, whereas, well, as I said at the beginning, with regard to trademarks or with regard to designs, that is not something which is being looked at by the examiner from the beginning. Whereas here, it is part of the examination, the examination ground, so to say. What is the situation on double patenting in your home jurisdiction? That is my last question. Have you seen these questions very often?